Good morning to all of you. Love Torts. Friends, in this video, we are going to discuss the specific tort. This is malicious prosecution. Malicious means to see that the others suffer. Definitely, it is an intentional tort. You have got a bad idea, you have got a bad practice of seeing that the others suffer. So please remember, it's a feeling of a need to see that the others suffer. Anikaramana paddhatilo cheyatam. So it is nothing but abuse of legal proceedings. So filing of false cases. Of course, we should not say false case, because in the Indian Penal Code, if you file a false case, it will be amount to offence under section 211 of the Indian Penal Code. But here, please remember, abuse of the legal procedure. No doubt, everybody can file a case. Who are going to obstruct you? Nobody can obstruct you. You can file a case, provided your case is genuine, provided you suffered any mental injury, provided you had any tort, then only you have to file. Otherwise, in order to make the others feel sorry or feel the moment to the court and other things, you should not do that like that. So, malicious prosecution, you can file it as a case of tort. So, the essential elements you have to remember that intentionally instituting and pursuing a legal case. You have to file a case first, and please remember, the case should be disposed of by getting you a clean chit. ఎవరి మీద అయితే కేసు వేశారో ఇతన్ని కేసు కొట్టేయాలి. కొట్టేసిన తర్వాత కూడా సో ది మ్యాజిస్ట్రేట్ హ్యాస్ టు అబ్జర్వ్ దట్ ఇట్ వాజ్ డన్ మెలీషియస్లీ టు గెయిన్ సమ్ అడ్వాంటేజ్. ఇది ప్రాక్టికల్ చెబుతున్నాను. నార్మల్లీ మ్యాజిస్ట్రేట్ షుడ్ ఒపైన్ ఎక్కడ లేదు, బట్ నార్మల్గా ఆ జడ్జిమెంట్లో రాసి ఉంటేనే జనరల్గా టేకప్ చేస్తారు, అయితే చేయరు. సో ద మ్యాలిక్యూషన్, సో ద ప్లెయింట్, because of this harassment, he has sustained some damages. Then only, so the term will be used as malicious prosecution. That means the intention to injure another person by filing the so-called unnecessary or frivolous పనికిమాలిన కేసులు వేయటం వల్ల. రైట్, కాబట్టి డోంట్ పుట్ ఎనీ ఫాల్స్ కేసెస్. మళ్ళీ అదే మాట వస్తుంది, డోంట్ పుట్ ఎనీ malicious prosecution. Right, now we are going to the examples. Very simple case, I tell you. Kamta Prasad versus National Building Construction Corporation Limited, 1992. Kamta Prasad case. Actually, Mr. Kamta Prasad, K. Prasad, he was entrusted with some building materials. సహజంగా ఈ బిల్డింగ్ పెద్ద కన్స్ట్రక్షన్, నేషనల్ బిల్డింగ్ ఎంబీసీసీ అంటే తక్కువ కాదు. ఆ మెటీరియల్ తీసుకొచ్చి డంప్ చేస్తారు. చేసినప్పుడు దే విల్ హ్యాండ్ ఓవర్ టు ది ఎంప్లాయీ. ఇఫ్ దే ఆర్ మిస్సింగ్, ఇఫ్ దేర్ ఇస్ అ షార్టేజ్, డెఫినెట్లీ దే విల్ ఫైల్ అ కేస్. సేమ్ థింగ్ హ్యాపెండ్ హియర్. సో దిస్ మ్యాన్ Kamta Prasad, a case was filed against him under section 409, that is misappropriation. ఆ కాలంలో ఏ కాలంలో ఉండొచ్చులే, ఏంటంటే వచ్చిన మెటీరియల్ డైవర్ట్ చేసేసి ఈ మనోడు ఇప్పుడు అక్కడ కావాల్సింది ఒక 100 ఐరన్ రాడ్స్ కావాలి సంథింగ్, దాంట్లో 50 వాడాడు, 50 కొంచెం మనోడు లాగేసినట్టున్నాడు. ఏదో నిజమవుతో మనకు తెలియదు, ఇతని మీద పెట్టిన కేసు అయితే అది. సో దట్ హీ హ్యాడ్ మిస్అప్రోప్రియేట్ సర్టన్ బిల్డింగ్ మెటీరియల్. బిల్డింగ్ మెటీరియల్ ఏముంటుంది? ఐరన్, ఇసుక, సిమెంటు, ఇవే కదా. సో వీటిని ఏదో మొత్తానికి మనోడు చేశాడని అభియోగం. అల్టిమేట్లీ వాట్ హ్యాపెండ్? సో మిస్సింగ్ ఆఫ్ సర్టన్ ఆర్టికల్స్ ఎనీవే. But the case ended in acquittal and is given benefit of doubt. Friends, yesterday in the class I told you what is benefit of doubt. The prosecution has to prove the case beyond all reasonable doubt. But if any iota of doubt is there, the benefit should go to the accuser person. That is the beauty of the entire judgment process or CRPC. ఏ మాత్రం అనుమానం ఉన్నా సరే ఈ బెనిఫిట్ అనేది ముద్దాయికి ఇవ్వాలి. సో ప్రాసిక్యూషన్ కాదు. సో అనుమానం ఉంది, సో ద కేస్ ఎండెడ్ ఇన్ ఎక్విటాల్. సో ఈయన కోపం వచ్చేసింది, నా మీద అన్యాయంగా కేసు పెట్టారా అని చెప్పి, దేర్ ఫోర్ హీ ఫైల్డ్ అ టార్ట్ కేస్ దట్ NBCC, National Building Construction Corporation Limited, they foisted a case against him, malicious prosecution, వాళ్ళ మీద కేసు వేశాడు. బట్ ప్లీజ్ రిమెంబర్, the court observed that there is reasonable and probable cause for prosecution. Number one, material shortage is very clear. It is entrusted to him. No doubt, వీడు చేశాడా లేదా దొంగలెత్తుకుపోయారా, దొంగలెత్తుకుపోతే రిపోర్ట్ ఇవ్వాలిగా. కాబట్టి there is a reasonable suspicion and probable cause also. NBCC గవర్నమెంట్ ఆర్గనైజేషన్ అనుకోండి, రిపోర్ట్ ఉంది పైనుంచి మళ్ళీ రాదు కదా, అందుకని చెప్పి డెఫినెట్ కేసు పెట్టారు. నో డౌట్ బికాస్ ఆఫ్ ది since the prosecution failed to prove the case beyond all reasonable doubt, the case is acquitted and benefit of doubt was given. That does not mean that they wanted to prosecute him maliciously. So no malice. So therefore no compensation to be given to him. Negative example. Now we'll go to another case, very famous case, Kamta Prasad versus Bhagat Singh. So actually it happens. So 1908. So the Bhagat Singh and another filed a case against Mr. Kamta Prasad before the police. So according to section 154 CRPC, they registered the case, they completed the investigation and they filed the charge sheet against him also. So they asked the so-called Kamta Prasad to produce certain witnesses and he has produced the stock witnesses, as a result of which the case was built very efficiently by the police and it was produced before the court. That means they have filed the charge sheet under section 173 CRPC. Right. So ultimately during the trial, the case ended in acquittal. Then the plaintiff, that is Mr. Kamta Prasad, who suffered loss by going to the court, by engaging a lawyer and so many things. He filed a case of malicious prosecution. The court held that. So the judgment also showed that the so-called Bhagat Singh others, they wanted to harass this man and therefore they filed the so-called malicious prosecution. Yes, awarded compensation. Then Dr. Abrath case, very famous case. Abrath versus Northeastern Railway Co. 1886. So actually an accident occurred in the railways area. So due to the accident, so many people injured, some people died also. I told you that railway claims tribunal, they will pay damages. So claim to the extent of 8 lakhs they will give. Right. The company paid damages to some deceased persons and also several injured persons. But they got a doubt on X. When X claimed that he was injured and he got insurance, he got the so-called compensation from the company, but they got a doubt. Immediately they have informed the same to their vigilance department, or they have engaged detectives suspecting that X was not a bona fide passenger. And the detective, after conducting his investigation, he has very clearly told that this X got a false certificate from Dr. Abrath. Dr. Abrath gave the medical certificate with artificially made wounds. Is it possible? Yesterday I told in the class, I should not openly tell. So yes, the doctor can make the so-called artificial wounds. Right. The police filed a case against Dr. Abrath, but it ended in acquittal. So therefore, Dr. Abrath brought a case of malicious prosecution. But the House of Lords held that the defendant, they have taken reasonable care because they employed the detectives to reveal the true facts and they honestly believed that the information was reliable. Therefore, no malicious prosecution. Then another case, Abdul Mazid versus Harbans Chobe. So 1974. Actually, Abdul Mazid was allegedly found in possession of a gold necklace, that is Hansuli. It is called in a dacoity case. So whenever a person is found in possession of Hansuli, he will be charged under section 412 of the IPC. But the trial disclosed that the police conspired, the SHO conspired with the so-called Harbans Chobe and foisted the case. Yes, very clear case of malicious prosecution. You have to pay compensation. And another case, this is relating to lawyers, Sachakam versus Dallu, 1983. So Dallu engaged our Sachakam as an advocate, but in his case, but Sachakam has taken up the case of the opposite party in a criminal case. And actually Dallu got a doubt that our lawyer is colluding with the other party. Therefore, he filed a case against the actually he brought it to the notice of the Bar Council. It's a different part ultimately. So it is very clearly established, but that the advocate did not do any misconduct because he has taken the civil case of this Sachakam, criminal case of the other party. So they don't clash with each other. It was held, yes, he is safe, lawyer is safe. So because this man filed a petition to the Bar Council. So the advocate filed a case of malicious prosecution against our so-called Dallu. But court said that yes, there is a suspicion, reasonable suspicion. That's why Blackstone's principle, not Blackstone's principle, I have forgotten. In Sussex case, Justice Abrath, I believe, he said that justice not only should be done, but should appear to have been done. When you are speaking to the other party, what they will think, definitely there is a reasonable suspicion. So therefore, it's not a case of malicious prosecution and no compensation is ordered. So with this, I am concluding. It has become a very lengthy video. Please, if you don't find time, so see it in parts, and definitely you will be enriched with the topic of the so-called malicious prosecution. Thank you very much.